So the travel rule has been around for a while, but recently FinCEN extended the scope of the travel rule to include something called a virtual asset service provider, which covers a variety of activities, primarily activities undertaken by crypto exchanges, uh, custodial wallet providers, and to some extent OTC cryptocurrency traders, right? And the travel rule is designed to create or alleviate the burden, the KYC AML burden of reciprocating financial institutions, right? And this applies to like money service businesses originally, right? And what it basically says in the context, in this new world context of cryptocurrency exchange, is that for transfers of value of 3,000 or more, whether that be in fiat or in crypto, there has to be certain information that must travel, right? Must be provided to the reciprocating or the partner financial institution, or in this case, virtual asset service provider. And that can include the originator's name, the account holder's name, account holder's number, account holder's address, basically all the identifying information that would allow the incoming or reciprocal financial institution to sort of meet their own KYC burden. And the problem in the crypto space is that that information is not always readily available. Now, if you're an MSB, if you're a money service business, it should be, in the sense that you have a requirement to conduct AML, KYC, and its subsets, and you should have that information. But it's something that in the crypto space, I see a lot of virtual asset service providers or crypto exchanges ignore it, right? Or maybe not willfully ignoring, but at least not following the letter of the law when the letter of the law is really new and really adopted from traditional banking services and the like. And so you have some holes in it. And the big thing for me is not so much the crypto exchanges, because there's some robust KYC going on in most legitimate exchanges, but it's also the OTC crypto and Bitcoin traders, right? I mean, obviously, if you're running an OTC desk, you're transferring more than 3,000 in most cases, and the question becomes, do you have to follow the travel rule? Well, the travel rule doesn't apply in certain circumstances. One being when you are the owner, right? When you have ownership of that asset. So if you're not acting as an intermediary, the travel rule sort of doesn't apply, right? So if you have custodial ownership, right, meaning like not a beneficial but a custodial ownership of the crypto or the funds, then the travel rule would not apply, right? But for these deals where you've got a sort of a daisy chain of brokers, right? It's an interesting postulate in the sense of like who actually has to apply the travel rule, and I would say most of the people in that chain have an obligation to do so, but I would say in practice, very few in fact do, right? So it's something to obviously consider. Now with crypto, the other problem is, because again the ownership aspect of it alleviates the requisite compliance with the travel rule. What if somebody simply sent crypto to a wallet address that they owned, then in turn sent crypto to a reciprocating financial institution or virtual asset service provider? In that case, the travel rule, you'd subvert it in a sense, because you have that indicia of ownership in terms of your own wallet. Now, the custodial wallet provider, depending on where the wallet was housed, may then in turn have the obligation, but for your purposes, you wouldn't necessarily do that. And there's some other exceptions, especially with the Electronic Money Banking Act and also ATMs, which I'll get into in a subsequent video. But the Travel Act and its extension to virtual asset service providers is something that I think is significant, because the burden can be significant, and I think it encapsulates, because that definition of virtual asset service provider is so large and so broad, right, that I think it encapsulates a lot of people that operating in the crypto space, but don't necessarily view themselves as financial institutions, don't necessarily, think maybe I'm not a money service business, I don't need to do it, but you in fact would have that obligation to do it. So definitely check me out. Hit me up if you have any questions. Adam Tracy, TRACY.io, and Adam at adamtracy.io. Happy to chat and discuss this further, and I'll be following up with a little more drilling down on how this works and what some of the exceptions are, especially for in the payment service provider space and the like. So I'll talk to you soon.